Hello, my name is Michael Tesoro and I prepared this presentation entitled Failed Flat Steel Fix Falls Foul of Federal Court, which is quite a tongue twister. And I'll be looking at the ACCC case against BlueScope Steel and Mr. Jason Ellis. I think the title really captures it all. It was an attempted price fix, so it was a failed attempt at engaging in cartel conduct. It related to flat steel products and obviously falls foul, so the federal court found it to be a breach of the legislation. Still to be a penalty hearing. It's a very long judgment, so it's about 450 pages long, and that's largely because the parties, the respondents, decided to put every issue in contest between the parties, so that resulted in Justice O'Brien having to make findings on a lot of issues. And finally, I think that image really captures the essence of the case, because here you have Jason Ellis trying desperately to arrange his price fix to increase margins in the industry, which was suffering significantly from a downturn in demand. And despite his valiant efforts, he really missed the mark pretty spectacularly, which ultimately will probably be in his favour, because I guess the penalty, which is yet to be determined for an attempt, will be substantially less than a penalty for a successful cartel arrangement. Bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice as Sarah Legal Consulting for the last 15 years, and I help companies, individuals with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a Director of Enforcement. Out of the presentation, I'll start with the background, then I'll look at some obstruction proceedings which were taken prior to this case being heard. Then I'll discuss the law. There's quite a bit of law that needs to be understood. Then look at the decision of Justice O'Brien, and then finish with some commentary. Now, the allegation was that BlueScope and Jason Ellis attempted to induce other suppliers of flat steel products to make an arrangement to increase prices for those products. And the conduct occurred many years ago, between September 2013 and June 2014. That may explain why it's a civil case, not a criminal cartel case, because it happened so long ago. And the alleged contraventions of this case are Section 45ZZRJ, which you may not be familiar with, and that's because the numbering of the cartel provisions changed a number of years ago, and Section 44ZZRJ no longer exists. It obviously has a shortened number nowadays. Now, the conduct, there's two bits of conduct. The first was that BlueScope and Ellis developed a strategy to increase the value to BlueScope and its distributors of flat steel products by introducing a benchmarking strategy. And the first step of that strategy was to provide distributors with a suggested RRP list, which had significantly higher prices and much larger margins for all the parties. Then to try and persuade those distributors to use that suggested or recommended resale price list to obviously increase their margins, and then causing BlueScope Distribution and another subsidiary, NZSA, to also set their prices for these products in accordance with the recommended resale price. And that's because many distributors saw the problem with pricing in the market due to BlueScope's own pricing. The second set of conduct related to an attempt between August 2013 and February 2014 to try and address competition from overseas steel manufacturers. And effectively what they were seeking to do was to speak to these overseas manufacturers and seek to restrict the volumes of steel that were being imported to Australia, to also persuade overseas manufacturers to increase their prices for products sold in Australia. And the threat was that they would initiate anti-dumping applications against the jurisdictions where these overseas suppliers were based unless they agreed to increase their prices. So there's two sets of alleged cartel agreements. Now, earlier on there was an obstruction case, and effectively the DPP took a case against Mr. Ellis, and he was charged with 2 counts of inciting the obstruction of a Commonwealth official pursuant to 11.41 and 149.1 of the Commonwealth Criminal Code. And what was alleged there, that Mr. Ellis had contacted other BlueScope executives and had sought to coach them as to the evidence they should give to the ACCC about the conduct which had occurred. And on the 1st September, Mr. Ellis pleaded guilty to a single rolled up charge of obstructing a Commonwealth official. And on the 15th December 2020, he was sentenced to a term of imprisonment of 8 months, but it was suspended on condition that he pay a recognizance of $1,000 and be on good behaviour for 8 months. For a term of 8 months and for a further period of 2 years. Now, the relevance of this is that in the case, the issue of the current case, the issue of the obstruction charge came up, and it was pointed out that his evidence in the obstruction case was clearly that he had engaged in the illegal conduct. He said, "I deeply regret the conduct that is the subject of those obstruction criminal proceedings. If I'd had my time again, I would not have engaged in that conduct. I accept that it was a serious error of judgment on my part. I pleaded guilty because I recognised that what I had done was wrong and because I recognised that it was an offence." However, in the current case, the civil cartel case, he gave significantly different evidence about that earlier conduct. He was asked, "So the things that you wanted Mr. Schultz to say to the ACCC weren't things that you thought were untrue. They were just things that Mr. Schultz's recollection about didn't accord with your recollection." And Mr. Ellis says, "Yes, that is correct. And that's one of the primary reasons why I didn't agree with the statement of facts presented by the ACCC." Question: Yes, your position is that, again, the information that you were providing to Mr. Schultz was true as you remembered it, as best as I could recall it. So here you have this difficulty where he's admitted to engaging in conduct in this obstruction case, and then he's effectively recanting on that evidence in the current case. Now that raises lots of issues. Firstly, raises a lot of issues as to his credibility. The judge is looking at 2 contradictory statements, both made on oath. So his chance of being believed in this case has just gone through the floor. Furthermore, there could be some implications for him down the track about having effectively recanted on his earlier guilty plea. Now, the law is a big part of this case, just different provisions, and section 44ZZRJ is the relevant provision, which is simply that a corporation contravenes its section if it enters into a contract arrangement or arrives at understanding which contains a cartel provision. That's the same nowadays, it's just got a different number. It's now 45AF. Now the second provision that's relevant is section 76(1), which is effectively the accessorial liability provisions of the Act, and as you can see there under B, it's an offence and it's a contravention to have attempted to contravene such a provision. So that's what has been alleged to have occurred both against BlueScope and Mr. Ellis, that they attempted to contravene the relevant cartel provision. Now the law about inducing or attempting to induce is important, and as you can see there, the quote, "The ACCC did not allege that the attempts by BlueScope or Mr. Ellis was successful. No understandings were ultimately arrived at. In some instances, the evidence suggests that BlueScope's proposal, whatever its ultimate characterisation, was rebuffed because the counterparties believed that the proposal would or might involve a contravention of the law." That's particularly with some of the overseas mills who are pointing out the probability that the conduct was against the Australian cartel laws. In other instances, the proposal was ignored because the competitive pressure from imported steel made BlueScope's proposal commercially unviable. So it didn't work for 2 reasons. A lot of the parties saw that it was a clear breach of the legislation, or alternatively, it was too big a change to make to the market for it to actually work. Now, an attempt has 2 elements. The first is conduct and the second is intention. Now, as stated by Justice O'Brien, the conduct element requires a step towards the inducement of the contravention, which is more than merely preparatory of the inducement to contravene, and which is immediately and not merely remotely connected with the inducement to contravene. So it's a step towards achieving an outcome. Can't be merely preparatory, it's got to be a bit more than that, and it cannot be merely remotely connected with the inducement. Secondly, the intention to bring about that which is attempted. So there has to be proven that there was an intention to achieve the outcome, but it is unnecessary to show the respondent knew that the contemplated understanding was unlawful. So you don't have to show that they knew it was a breach of the cartel laws. However, knowledge of the essential facts that would have rendered the alleged understanding unlawful is necessary before there can be intent. So that would involve such things as the knowledge that you were approaching a competitor. There has to be, cartel has to involve a contact with a competitor, and also that the effect of the agreement, arrangement, understanding would be to increase prices or to set a floor price. So what the judge stated at 144 was, as to the conduct element of an attempt to induce, in my view, a person may be found to have attempted to induce a counterparty to reach a price fixing understanding, notwithstanding the person never expressly asked the counterparty for a commitment. And this is a big issue in relation to contracts, arrangement, understandings, is whether there needs to be commitment shown. And clearly where there's a actual successful cartel arrangement, commitment does need to be shown. But what he's saying here is when you're looking at an attempt to induce, commitment is not required. So that's important to be aware of that fact. I guess it's obviously a lower onus in one sense, that you don't have to show that the party who was approached was committed to acting in a particular way. And then he says at 147, an attempt to induce a person to reach a price fixing understanding does not require assent to be achieved. It requires, as I said earlier, a step towards the inducement that is more than preparatory and is not merely remotely connected with the inducement. So you don't need commitment, you don't need assent. And that's quite relevant because it's clear that Mr. Ellis thought that there had to be commitment. So attribution is also important, and this is interesting because you have a section 84(1) of the Competition and Consumer Act which provides for attribution of liability. And what Justice O'Brien concludes here was, having regard to the legislative text and history, it is clear that the extension of section 84(1) to the cartel provisions is consistent with and indeed confirms the view that that section applies to proof of intention elements of cartel conduct. So basically 84(1) is relevant to proving the intention element under the cartel provisions. However, that section is not proof required for proof of intention associated with accessorial or ancillary liability provisions under section 76. So effectively 84 applies to the intention elements in the primary provisions, but not to the accessorial liability provisions in 76. That means, as you can see in the second paragraph of 172, it follows that the requisite intention of BlueScope and by extension Mr. Ellis in respect to the alleged attempt to induce counterparties to arrive at understanding must be proved through the application of common law principles of attribution. So you've got two different rules of attribution. You've got the attribution under section 87(1), which applies to the primary contravention, and then you have the common law principles which apply to the accessorial provision. So that's important to be aware of that legal issue. So a very significant issue in this case was the credit that Mr. Ellis had in terms of evidence, and I must say that he appears to be one of the worst witnesses that I've ever seen in a case based on the comments of Justice O'Brien. And this is just a few examples. From the totality of the evidence given by Mr. Ellis in the proceedings, I formed the impression that Mr. Ellis was an unreliable, unsatisfactory, and in some respects dishonest witness. Then you can see that he had a view, Justice O'Brien, that Mr. Ellis was recreating a version of events and he would often distort the truth. He had a propensity to obfuscate, refusing to admit obvious facts, and that was something that came through in the judgment. There'd be a statement by Mr. Ellis and then a document put to him which contradicted what he said, and then he'd seek to change his evidence to suit the relevant provision or the relevant evidence. There was also a conclusion that elements of Mr. Ellis's evidence appeared rehearsed and contrived. And then the final quote there I put in was, aspects of Mr. Ellis's evidence concerning his criminal conviction in September 2020 on the charge of inciting the obstruction of a Commonwealth official, which I've mentioned earlier, defied belief. So this is a very important issue about putting a witness in the box who really is going to have a very low level of credibility with the judge. You're obviously going to lose that case. Now, some of the examples of some of the evidence that was put here, here you've got an example of a conversation with Hennessy where he's saying, this is serious. And Ellis is saying to him, just say that the meeting with Griff Wright was along these lines. We agreed to buy steel from him and he said no, and we asked to sell steel to him and he said no. And then we had a specific discussion afterwards and agreed that I needed to go to the overseas manufacturer to break the channel. And so he's trying to coach Hennessy into giving false evidence, and this is an obstruction case. And Hennessy says, mate, I'm going to be in front of a barrister and under oath. And then Ellis says, we're smart guys too. And I guess overconfidence, a bit of hubris that sort of could explain their way out of these particular problems. And then Hennessy says, so buy no and sell no, and then we decided we need to bypass Griff. Yes, this is going to be a bad year for both of us. I think that's the understatement of the year. I will be having one of these interviews too. I'm sorry you are in this position. And the Hennessy says, okay, we're in this together. And then this is also quite bad. I'm preparing an affidavit with my lawyer. I'll give you a copy early next week so you can review it and give me some feedback. So that's obviously clearly colluding between the witnesses to get their story straight. The evidence was quite strong in relation to obstruction charges, and this all goes to seriously damage Mr. Ellis's credit before the judge. Now, the first issue that the judge had to determine was the competition condition. Effectively, the BlueScope was in competition with these various distributors, and after looking at a lot of evidence, defining markets, a big chunk of the judgment, Justice O'Brien was satisfied that the competition condition was satisfied and that BlueScope was in competition with Selection Steel, Apex Steel, Southern Steel, Vulcan Steel, Selwood Steel, CMC Steel and One Steel. So this is a case of a lot of arguments being put to the court without really much prospect of them being successful, and requiring the judge to go to a lot of effort to, I guess, make a finding about something that is quite obvious. So I don't quite understand why people run litigation in this way. Now, commitment, as I said earlier, that Mr. Ellis had this strange view that if he was not getting commitment out of the other side, then he couldn't be guilty or liable for cartel conduct. So as the judge said there, he inferred that Mr. Ellis had learned the case law established that a mere hope or expectation that a party will act in a particular way was insufficient to constitute an understanding, and there he refers to the APCO case. So here's Ellis believing, as long as I don't get a commitment from the various distributors, I can't breach the law. And that was a mistake, because it was an attempt to induce, and accordingly saying in his evidence consistently that he hoped people would do things, that he had no expectation that they would actually follow the recommended resale price list, didn't make any difference to his liability. And the judge finally concluded that this element of Ellis's evidence was contrived. So he did actually have more than a hope that the distributors would follow the price list. He just framed it in his evidence as a hope in an attempt to avoid the commitment issue. Now, some of the evidence that was put forward included a document which referred to a project was undertaken to incorporate the concept of recommended resale price into the distribution sector. And as you can see, the purpose of this particular strategy or project was clearly spelled out in their own internal documents. The aim was to improve the profitability of our distribution channel customers by attempting to set a price floor for each major product category within the sector. So this is to ensure that BlueScope subsidiaries which were involved in distribution raised their prices to the price list level, and that all the other distributors did the same, and therefore nobody sort of lost out on sales but achieved much higher margins. And then the next observation, we have not yet measured success, but anecdotal feedback has suggested that our distributors have had some wins. Well, that doesn't seem accurate ultimately. There seemed to be some willingness for distributors to implement the proposed price list, but there's no suggestion that it was actually successful in any respect. The concept is attempting to be expanded in sheet and coil processing as well as building market roll formers. So there was an idea that we'll start with flat steel products and then roll it into other product areas in the future. So a lot of evidence like that, it's really hard to put the proposition that there was no intention to try and increase prices and margins in this particular flat steel market. There was further evidence, and this is the comment by Justice O'Brien on that previous document, where he notes that the document was very significant because it clearly states that the aim of this RRP strategy was to improve profitability of their distribution part of the business, attempting to set a floor price for these products in each of the major categories. And they're trying to move from a cost plus approach to a list plus minus approach. So effectively start with a list price which gives them a very good margin and then maybe give a small rebate off that amount, rather than starting with the cost of production and adding a small margin on top of that. So the evidence was quite clear as to what the purpose of the strategy was. There was further evidence before the court, and this was in a written statement from Mr. Hennessy, that there was a variety of feedback received from distributors about this proposal. A number of distributors said that the recommended resale price was too high, so it was too big a jump from the existing price, so they get too much resistance from their customers. Others noted that SIPA needed to add more detail, so there needed to be more explanation as to how this was going to work. And then effectively the proposal was that the recommended resale price proposal was never implemented because of the complexity of the responses. So effectively it was unsuccessful in relation to the flat steel products and was never actually implemented in relation to other product areas which were identified in that earlier document as being candidates for a similar resale price list. So the findings made by the judge were that the conduct of the business was an undertaking with the commercial intention of assisting to facilitate coordinated price increases in the distribution market. Furthermore, that BlueScope and Ellis had attempted to introduce 9 suppliers of flat steel products in Australia, and that involved those companies there: Selection Steel, Apex Steel, Southern Steel, Vulcan Steel, Selwood Steel, CMC Steel and One Steel, and also one import trader, the Wright Steel CITIC JV, and one overseas steel mill, which I'm not too sure how to pronounce that. So the findings were that the attempt to induce had occurred in relation to those 9 suppliers. There was also findings made that an attempt to induce a price fix understanding does not require assent to be achieved. So as we discussed earlier, you don't require commitment or assent to establish an attempt to induce. It is not necessary for such conduct to have reached an advanced stage, or for the precise terms of the proposed understanding to have been formulated. So this is important law in terms of the evidentiary requirements in relation to attempt to induce. It's significantly lower, obviously, than a bona fide agreement that's put into effect. But it can't be just merely preparatory or remote. That's the thing to remember. There is some threshold that has to be got over, but it's not to the stage where it has to be advanced or precisely formulated. So he was satisfied based on the evidence that BlueScope and Mr. Ellis had sought to implement the benchmarking strategy and the overseas mill strategy from the beginning of 2013 through to 2014, and intended to induce a consensus or meeting of minds that they would do particular things. So they'd follow the resale price list put out by BlueScope to create this floor price for the sale of flat steel products, and also that there would be some restriction on the level of imported steel to Australia, and that would be either to reduce the level of imports, to increase the price of imports, or to completely cease sending product to Australia. So just some commentary about the case. Like, it's a very long case, and a lot of the case is, as I said earlier, Justice O'Brien dealing with issues that have been put into contest by the respondents, and many of these issues really had no merit whatsoever, and I don't understand what the point is of just trying to get lucky on issues that really have very limited evidentiary basis. But that forced the judge to go through a lot of issues. Ultimately, it is only an attempt to induce. Like, let's face it, it's an attempt to breach the law which failed. So there's clearly no detriment arising to customers as a result of the conduct. So in that sense, it's a less serious breach, and I don't quite understand why so much effort is thrown at defending an attempt to induce case. The case was fought very, very hard, and I think it's going to be interesting what penalties that Justice O'Brien decides are appropriate in the case. I think it was an attempt to achieve a very extensive and a very potentially detrimental cartel that would have impacted the whole of the Australian economy. So in that respect, it should be a fairly large penalty, but ultimately, as I said, there's no detriment, so that's got to bear in the mix. As I said earlier, some issues were really uncontroversial, but they were contested, which I guess there's a litigation strategy behind that, but I don't think I understand it. Dragging cases on so long, particularly when you've got a witness whose credibility is so weak, isn't, in my view, the best strategy, but there are probably reasons for the strategy undertaken. Ellis' reliability and credibility was a very key factor, and I think I haven't read a judgment where the judge has been so unimpressed with the witness, and the witness has tried so consistently to put a version of events to the court based on a misunderstanding of the law, believing that if he held a hope but there was no commitment, that somehow he would avoid liability. There are some serious implications for Mr. Ellis about his effectively recanting on his guilty plea in the obstruction matter. Now, there's got to be a strong suggestion that he's perjured himself somewhere along the line, and it'd be interesting to see whether any further action arises from that. And one issue that I'm not too sure about, but you'd think that if you make a guilty plea and you get a recognizance bond, and then you subsequently recant on your admissions, that maybe the recognizance bond has been breached, and you potentially could end up having to serve your time in jail. I don't really know, but it seems like something that I suspect the ACCC and the DPP are looking at very carefully, and that after the penalty judgment is handed down, there may be some further activity in relation to that. And I think it also shows the ACCC's determination to pursue these long, hard cases. Like, it's not the case of the century in terms of being an attempt to induce, and it was a very hard case with a lot of issues being contested, but they kept at it, they pursued it, they ensured that they didn't accept or didn't allow the obstruction conduct to go unpunished. And I think it says a lot for the ACCC's resolve in pursuing these particular cases. So I guess the next stage will be how big a penalty is imposed by Justice O'Brien. I probably wouldn't even hazard a guess as to what the penalty is going to be in this particular case, but that's probably the next instalment which we'll be looking at for probably later on in the year. So that's all I had. An interesting case. Hopefully that saves you a number of hours of time in reading the whole judgment, and I think that picks out the major issues of importance, both legally and factually, for lawyers who practice in the area. If you have any questions about this presentation, feel free to give me a call or send me an email. Bye bye.